Tuesday morning, 9:06 a.m. A federal judge in Washington did something judges almost never do in open court. She stopped Trump's lawyer mid-sentence. Not after the argument, not after the filing. Mid-sentence. And then she said the 9 words that froze the entire courtroom. Counsel, which version of your story is true? That was the moment everything changed. Because for 3 weeks, Trump's legal team had been telling one court that a disputed election strategy memo was only a draft political document. No legal force, no official purpose, no operational plan, just a campaign memo. But 600 miles away in a different federal court, the same legal team had described that same memo as a privileged legal strategy document prepared for implementation review. Implementation review. That is the phrase that blew up the hearing. Because you cannot tell one judge the memo was meaningless political brainstorming and tell another judge it was serious enough to hide behind privilege. One document, 2 courts, 2 stories. And this morning, Judge Elena Marris caught it. Page 18 of the Washington filing says the memo was non-operational political messaging. Page 7 of the Atlanta filing says the memo was prepared for legal implementation assessment. Those are not the same thing. One says it was talk, the other says it was a plan. And once Judge Marris put both filings side by side, Trump's entire defense strategy cracked in public. Here is what they are not covering. The person who exposed the contradiction was not a senator, not a prosecutor, not a rival campaign, not a cable news host. It was the one staffer Trump's team treated like she did not matter. A former campaign legal operations coordinator the filings call Witness 6. They called her administrative. They said she only routed documents. They said she had no authority, but she controlled the labels. She knew which file was called political, which file was called legal, which file was marked privileged, and which version went to which court. And according to prosecutors, Witness 6 gave them the sentence that now sits under this entire case. They changed the label after the subpoena. They changed the label after the subpoena. That is not commentary. That is not opinion. That is the thread Judge Marris pulled this morning. And when she pulled it, 3 courts, 3 filings, and one 23-page memo started unraveling at the same time. This was not an accident. This was not a typo. This was not a junior lawyer using sloppy language. The same senior attorney signed both filings, same signature block, same firm, same client, same memo. 2 different explanations. And the court noticed. By 9:18 a.m., Judge Marris ordered Trump's legal team to explain the contradiction under oath. By 9:31 a.m., prosecutors requested permission to submit the Atlanta filing into the Washington record. By 10:04 a.m., Trump's team asked for a sealed emergency conference. Denied. By 10:11 a.m., the judge said the issue would be handled in open court because, quote, the public record created the problem. The public record will address it. That line is why today matters. Not because Trump's lawyers got embarrassed. Lawyers get embarrassed. Not because a judge got irritated. Judges get irritated. Today matters because the court is now asking whether Trump's team used 2 different legal narratives to block the same evidence in 2 different cases. That is not embarrassment. That is exposure. And the worst part for Trump? The contradiction was not found by prosecutors. It was found by Judge Marris's clerk, a 27-year-old former election law researcher named Daniel Race, who noticed one phrase in the Atlanta docket at 1:42 a.m. and flagged it before sunrise. That phrase was implementation assessment. 2 words, that is all it took. 2 words turned a normal Tuesday hearing into a legal earthquake. Stay with me because this gets worse as every 6 minutes. Current situation. Trump's legal team is now facing a court-ordered sworn explanation. Judge Marris has demanded a side-by-side chart of every statement made about the election strategy memo in every court where it appeared. Federal prosecutors are asking whether the contradiction opens the door to discovery. The Atlanta judge has been notified. A judicial ethics referral is being discussed. And the memo itself, which Trump's team spent 3 weeks trying to bury, may now become the most important document in all 3 cases. That is the snapshot. Now let me show you how we got here. 3 weeks ago, federal investigators subpoenaed a document called the State Certification Response Memo. Trump's team said it was a political draft. Their argument was simple. This memo was campaign speech, protected political discussion, not legal instruction, not official action, not evidence of intent. That was the Washington argument. Then, 9 days later, in Atlanta, Trump's team tried to block a state-level demand for the same memo. But there, they needed a different shield. They said the memo was privileged, prepared for legal review, created for implementation analysis, shared with attorneys, protected from disclosure. That was the Atlanta argument. The problem? Both arguments cannot be true at the same time. If it was just political messaging, why was it privileged legal strategy? If it was privileged legal strategy, why did they tell Washington it had no operational purpose? That contradiction sat quietly across 2 dockets for 9 days. Nobody connected it. Not the press. Not the pundits. Not even prosecutors at first. Then last night after midnight, Judge Marris's clerk compared the filings. One phrase jumped out. Implementation assessment. He pulled the Washington brief, page 18, non-operational political messaging. He pulled the Atlanta brief, page 7, prepared for legal implementation assessment. He sent the comparison to Chambers at 1:58 a.m. By 7:12 a.m., Judge Marris had read both filings. By 8:03 a.m., she added a new item to the hearing agenda. By 9:06 a.m., Trump's attorney was cut off in open court. And by 9:08 a.m., the entire room understood the trap. The defense had not been attacked. It had contradicted itself. Subscribe, because this is the kind of detail that decides cases while everyone else is watching speeches. Let's talk about the memo. The state certification response memo is 23 pages. Trump's team says it was a draft. Prosecutors say it was a roadmap. The memo allegedly lays out 3 tracks. Track 1, public messaging around disputed certification. Track 2, pressure points involving state officials. Track 3, legal mechanisms for delaying recognition of results. Track sounds political. Track 2 starts to sound operational. Track 3 is where the danger lives, because page 14 reportedly contains a section titled Judicial Delay Window. That phrase is why prosecutors want the memo. Judicial delay window. Not media strategy, not campaign messaging, a delay window. According to the Washington filing, that phrase was rhetorical shorthand. According to the Atlanta filing, that phrase was part of a legal strategy analysis. Again, 2 stories. One court gets harmless phrase, another court gets privileged legal analysis. That is why Judge Marris erupted. At 9:22 a.m., she asked Trump's lead attorney, was the memo political messaging or legal implementation? He answered, Your Honor, it depends on context. Wrong answer. You could feel the room change, because judges hate that answer when the context is 2 sworn filings. It depends is fine in law school. It is dangerous in court. Judge Marris leaned forward and said, the context is your signature. Silence, 7 seconds. Nobody moved. Trump's attorney looked down. The second chair reached for a folder. Prosecutors stopped taking notes and just watched. That was the first real collapse, not the contradiction, the silence. Because when a lawyer has a clean explanation, they give it fast. When a lawyer needs time, they reach for paper. He reached for paper. At 9:26 a.m., the judge ordered him to read both lines aloud. First, the Washington filing. The document was a non-operational political messaging draft with no legal effect. Then, the Atlanta filing. The document was prepared for legal implementation assessment and is therefore protected from compelled disclosure. Judge Marris asked, do you maintain both statements? Trump's attorney said, we maintain both positions as applied to separate proceedings. That was the second wrong answer. Because now he was not denying the contradiction. He was defending it. And that opened the door. At 9:31 a.m., prosecutors stood up. They requested 3 things. 1, permission to submit the Atlanta filing into the Washington case record. 2, an order requiring Trump's team to identify every person who reviewed the memo. 3, limited discovery into whether the memo was used operationally. That third request is the bomb. Limited discovery. That means emails, calendars, draft histories, meeting notes, distribution lists. Who got the memo? When did they get it? What did they do after receiving it? Did anyone act on it? Did anyone forward it? Did anyone say, use this? Did anyone say, do not put this in writing? The contradiction gave prosecutors the opening they had been waiting for. Before today, Trump's team had kept the fight narrow. Is the memo privileged? Is it political speech? Can prosecutors see it? After today, the fight becomes larger. Did Trump's team mischaracterize the memo to 2 different courts? That is a different question. And it is a dangerous one because courts can forgive aggressive advocacy. They do not forgive being played against each other. Now, here's the part that makes this story bigger than one memo. At 9:44 a.m., the Atlanta court received notice of the Washington contradiction. Not from prosecutors, from Judge Marris. A judge notified another judge. That is rare. Judges do not usually send flare guns across jurisdictions unless they believe something serious is happening. The notice was short, 4 sentences. But the final sentence is the one that matters. This court has identified potentially inconsistent representations regarding the same document now pending before both jurisdictions. Potentially inconsistent representations. That is polite judicial language for someone needs to explain themselves. By 10:02 a.m., Judge Raymond Cole in Atlanta entered his own order. He gave Trump's team 6 hours to explain whether the Washington filing had been disclosed when they argued privilege in his court. 6 hours, not 6 days, 6 hours. That means Trump's lawyers are now answering to 2 judges at the same time about the same contradiction. Washington wants to know why they called the memo political. Atlanta wants to know why they called it legal. And both courts want answers today. That is the pressure cooker. This is complex, but stay with me, because the contradiction only matters if it changes the memo's legal status. And it does. If the memo was political, prosecutors can argue it is not privileged. If the memo was legal, prosecutors can argue Trump's team misled Washington by calling it non-operational. If the memo was both, prosecutors can argue it crossed from speech into action. And if it crossed into action, the memo becomes evidence of intent. Intent is the whole game, not whether Trump gave speeches, not whether he complained publicly, not whether advisors floated ideas. Intent. Did he know what the plan was? Was the plan merely messaging, or was it designed to create delay, pressure officials, and shape legal filings? The memo sits right at that intersection. That is why Trump's team fought so hard. And that is why 2 inconsistent stories are so dangerous. Now let's return to witness 6, because this is where human nature kicks in. Every powerful operation has someone it underestimates, someone who schedules the meetings, someone who receives the drafts, someone who uploads the files, someone who hears senior people say, send the clean version, someone who knows that final was never actually final. Witness 6 was that person. According to prosecutors, she handled document routing between the campaign, outside counsel, and state-level advisors. That means she knew who received drafts. She knew which version went where. She knew what was legal, what was political, and what was both. Last month, prosecutors interviewed witness 6 for 4 hours. Trump's team dismissed her as administrative. That was mistake number 1. Because administrative people often know more than principals. They see the emails. They schedule the calls. They upload the drafts. They rename the files. They know when final becomes final clean, becomes final privileged. And witness 6 reportedly told prosecutors one sentence that now looks explosive. They changed the label after the subpoena. That sentence did not matter much before today. Now it matters a lot. Because if the memo was originally treated as political, then relabeled as legal after investigators came asking, that helps explain the 2 stories. Washington got the original posture. Atlanta got the protection posture. That is what prosecutors are now circling. At 10:19 a.m., prosecutors asked to submit witness 6's interview summary under seal. Trump's lawyers objected immediately. They said the interview was unreliable. They said she had no authority. They said she misunderstood internal labeling. They said she was disgruntled. Of course they did. That is the standard playbook. Attack the witness before the witness becomes the timeline. But Judge Marris did not bite. She said, reliability can be tested. Relevance is apparent. That is a devastating line because it means witness 6 is in. Maybe not publicly, maybe not fully, but the judge sees the relevance. And if the judge sees the relevance, prosecutors get room to dig. Now watch how fast the story escalates. 10:36 a.m., a second contradiction appears. This one is not about the memo. It is about who saw it. In Washington, Trump's team said the memo was not distributed to decision-making principals. In Atlanta, they said the memo was circulated among senior legal and political leadership. Again, those are not the same thing. Not distributed to principals, circulated among senior leadership. Which one is true? Judge Marris asked exactly that. Trump's attorney tried to answer, Your Honor, senior leadership does not necessarily mean decision-making principles. That answer may be technically possible, but it sounds ridiculous to normal people. And courtrooms are full of normal people wearing serious clothes. Senior leadership but not decision makers? Legal implementation but not operational. Political draft but privileged. At some point, the language stops sounding precise and starts sounding slippery. That is when judges get angry. And Judge Marris was angry now. At 10:42 a.m., she ordered Trump's team to produce a distribution chart by 5 p.m. Every recipient, every version, every date, every label, political, legal, privileged, draft, final. Shared externally, shared internally. She wants the whole map. That is the worst possible outcome for Trump's team. Because when a judge asks for a distribution chart, the fight is no longer theoretical. It becomes mechanical. Who had it? When? Why? That is how documents become witnesses. At 10:58 a.m., Trump posted. That made it worse. He wrote, "Radical judge wants to criminalize legal advice and campaign speech. Total election interference. My lawyers did everything right." That post was online before the hearing ended. Prosecutors printed it. By 11:07 a.m., they asked the court to preserve all public statements about the memo and the filings. Trump's team objected. Judge Marris granted the preservation request. Now, Trump's own post becomes part of the record, not because speech is illegal, because timing matters. A judge asks whether your team gave two stories. Minutes later, you claim your lawyers did everything right. That may be politics outside court. Inside court, it is state of mind. It shows he knows the issue. It shows he is trying to frame the issue. It shows he understands his lawyers are under scrutiny. Every public statement becomes a shadow filing. That is why disciplined defendants stay quiet. Trump does not stay quiet, and prosecutors know that. They do not have to bait him. They just have to wait. Now, here is what most coverage will miss. The judge did not accuse Trump's lawyers of lying. Not yet. She did something more dangerous. She asked for a sworn reconciliation. A sworn reconciliation is not a press statement. It is not spin. It is not cable news. It is a court-ordered explanation signed under penalty. That means every word in their response creates new exposure. If they say the memo was political, Atlanta privilege weakens. If they say it was legal, Washington misrepresentation becomes worse. If they say it was both, prosecutors argue it had operational purpose. If they blame a drafting error, the same senior attorney signed both filings. If they blame local counsel, the national team coordinated both cases. If they blame context, the judge already said the context is the signature. No clean exit. That is why this is a trap. Not because prosecutors invented it, because the filings created it. By noon, 3 things are happening at once. Washington court, sworn reconciliation, due by 5 p.m. Atlanta court. Explanation due by 4 p.m. prosecutors. Emergency discovery request pending. Trump's legal team now has 4 hours to produce answers that do not make either court angrier. And then the third court enters. Yes, a third court. At 12:18 p.m., a filing in a Pennsylvania election-related civil case is flagged by a watchdog group. The same memo is referenced there, too. But in Pennsylvania, Trump's lawyers called it an internal communications plan unrelated to legal strategy. So now we have 3 descriptions. Washington, non-operational political messaging. Atlanta, legal implementation assessment. Pennsylvania, internal communications plan unrelated to legal strategy. 3 courts, 3 labels, same memo. That is not a contradiction anymore. That is a pattern. And courts care about patterns. At 12:44 p.m., prosecutors update Judge Marris. They include the Pennsylvania reference. Trump's attorney objects and says the Pennsylvania case is irrelevant. Judge Marris responds, it became relevant when the same document received a 3rd description. There it is. 3rd description. That phrase becomes the headline. Not 2 stories anymore. 3. The political story, the legal story, the communications story, all for the same 23-page memo. And each label was used for a different advantage. Political in Washington to avoid intent. Legal in Atlanta to claim privilege. Communications in Pennsylvania to avoid discovery. That is the theory prosecutors are now building. Use whatever label blocks the threat in front of you. But once the labels are compared, the defense starts looking like a shell game. That is the human hook. Viewers understand shell games. They understand someone moving the cup. They understand, wait, you said it was under this one. Now you say it is under that one. They do not need a law degree. They need common sense. And Judge Marris is turning common sense into court orders. Now, the first resignation rumor hits 1:13 p.m. A senior associate on Trump's national litigation team removes the case from her professional biography. Small detail, easy to miss. But legal reporters notice. By 1:31 p.m., two sources say she was one of the attorneys who helped prepare the Atlanta filing. By 1:52 p.m., her firm says she is on leave from case duties. On leave, not withdrawn, not fired. On leave. That means something happened internally. Maybe she raised concerns, maybe she signed off, maybe she refused to sign off. We do not know yet. But timing matters. 3 hours after a judge identifies inconsistent representations, an attorney connected to one filing disappears from case duties. That is not random. Trump's team says it is unrelated. Of course they do. But the court will ask, because Judge Marris just ordered a distribution and drafting chart. Drafting chart. That means who wrote what, who edited what, who approved what, who signed what. If that associate touched the Atlanta language, she may become a witness in the contradiction fight. Lawyers hate becoming witnesses. When lawyers become witnesses, cases start eating themselves. That is where we are now. The defense is no longer just protecting Trump. It is protecting its own process. And once a legal team has to defend its process, the client is in trouble. At 2:06 p.m., witness 6 reappears. Prosecutors file under seal a supplemental summary from her interview. The public docket only shows one phrase: document label change after external demand. External demand means subpoena, or court order, or investigator request. So now the timeline becomes sharper. Before demand, one label. After demand, another label. Before danger, political. After danger, privileged. That is the theory. Trump's team says no. They say the memo always had mixed legal and political functions. That is possible. Politics and law overlap. Campaigns have lawyers. Lawyers review messaging. Messaging affects legal posture. Fine. But then why tell one court it was unrelated to legal strategy? That is the Pennsylvania problem. If it was always mixed, why not say that everywhere? Because the label changed depending on the threat. That is what Judge Marris is testing. At 2:33 p.m., Atlanta Judge Cole issues a second order. He wants to know whether the privilege log in his case identified the memo by the same title used in Washington. It did not. Washington title, State Certification Response Memo. Atlanta title, Certification Litigation Strategy Analysis. Pennsylvania title, Internal Communications Plan. 3 titles. Same document. That is bad, because different titles make cross-case detection harder. Maybe innocent, maybe clerical, maybe strategic. But after 3 different descriptions, 3 different titles look suspicious. Judge Cole gives Trump's team until 6 p.m. to provide document control numbers linking all versions. Document control numbers. That is how judges cut through fog. Titles can change. Descriptions can change. File names can change. Control numbers expose whether the same underlying document is being relabeled. And if the control numbers show the same document was renamed across courts, the explanation has to be very good. At 3:05 p.m., Trump's spokesperson goes on television. Mistake. He says this was a standard legal memo, nothing more. Standard legal memo. Remember that. Because standard legal memo helps Atlanta but hurts Washington and Pennsylvania. Within 9 minutes, prosecutors clip the statement and file a notice. Not because spokesperson statements decide privilege, but because the public team just picked one label, legal memo. That contradicts the non-operational political messaging position. Trump's messaging team is now damaging Trump's legal team. That happens when the war room and courtroom are not aligned. The war room wants outrage. The courtroom needs precision. Outrage gets clicks. Precision keeps sanctions away. Today, outrage won, and the court noticed. At 3:27 p.m., Judge Marris asks whether Trump's legal team controls public statements regarding the memo. His attorney says, "We do not control political communications." Judge Marris replies, "But your client controls his filings." That is the line. Public chaos may be outside counsel's control. Court filings are not. The judge is separating noise from responsibility. And responsibility points back to the signature. Same attorney, same memo. Different courts, different labels. At 3:58 p.m., the first deadline hits. Atlanta explanation due. Trump's team files 11 pages. The core argument. The memo evolved over time. Early versions were political. Later versions received legal review. Different courts address different versions. That is their escape hatch. Different versions. Smart. Probably their best move. But then comes the problem. They attach a version chart, and the chart shows the Washington and Atlanta versions share 19 identical pages. 19 of 23. Same sections, same language, same footnotes, same formatting. Only the cover title and privilege markings changed. That is not enough to cleanly say these were different documents. Judge Cole sees it immediately. At 4:21 p.m., he orders Trump's team to produce the native files. Native files, that means metadata. Creation dates, edit history, authors, file paths, who renamed it, when the privilege marking was added, whether political draft became legal strategy analysis before or after the subpoena. Native files are where stories go to die. PDFs are polished. Native files, remember, that is why this order matters. Now, Washington deadline, 5 p.m. Trump's team files the sworn reconciliation. 22 pages, signed by the senior attorney. The argument: no inconsistency exists because the memo had dual character, legal and political, messaging and implementation, draft and analysis. They are trying to merge the three stories into one. That is the only move left. But on page 16, they make a mistake. They write, the document's legal significance became apparent after further review. After further review. That phrase may haunt them. Because if the legal significance became apparent later, then when did they start claiming privilege? Before or after the subpoena? Before or after witness 6 says the label changed? Before or after the Atlanta filing? Prosecutors immediately seize on it. At 5:19 p.m., they file a response. Defendant now admits the document's legal significance was identified after the fact. Trump's team says that is a mischaracterization. Maybe it is. But the phrase is in their filing. After further review, and now the judges have it. At 5:46 p.m., Judge Marris issues the order of the day. 4 parts. 1. Trump's team must produce native files by noon tomorrow. 2. Witness 6's sealed interview summary will be reviewed in camera. 3. Prosecutors may conduct limited discovery into document labeling and distribution. 4. The court reserves ruling on sanctions. Reserves ruling on sanctions. That is the thunderclap. Not sanctions imposed, sanctions reserved. That means the judge is not done. She is watching. She is giving them one more chance. She is also warning them that this can get worse. And it can, because limited discovery opens doors. Tomorrow, prosecutors can ask, who renamed the memo? Who added privilege markings? Who approved the Atlanta description? Who approved the Washington description? Who knew about both? Did Trump review the memo? Did Trump discuss the memo? Did Trump's public statements track the memo's language? Did any witness receive instructions about how to describe it? That is how a document labeling dispute becomes an intent investigation. And that is why Trump's team wanted the emergency conference sealed, not to protect secrets, to prevent the contradiction from becoming the story. They failed. Now the contradiction is the story. By 6:12 p.m., Trump posts again. He writes, judges are working together against me. Same old witch hunt. They hate free speech. That post creates a new problem. Judges working together. He is referring to Marris notifying Cole. That was a judicial notice about inconsistent filings. Trump frames it as coordination. Prosecutors will argue it is an attack on the judiciary, maybe not enough for a gag order, but enough to show escalating pressure. And the timing, again, is terrible. Minutes after sanctions are reserved, he attacks the judges. At 6:30 p.m., Judge Marris adds tomorrow morning status conference, 9 a.m. Topic: compliance with production and public statement preservation. Public statement preservation, that means posts, clips, statements, interviews, campaign emails, donor messages. Everything said about the memo now matters. Because if Trump's public team keeps calling it legal, political, fake, privileged, irrelevant, and confidential all at once, prosecutors will build the same pattern outside court that the judge found inside court. Different labels for different audiences. That is the theme. At 7:04 p.m., the associate who went on leave hires independent counsel. That is not confirmed by the court yet. But if true, it is huge. Because when a lawyer hires a lawyer, the case has entered a new phase. She may be protecting herself. She may be preparing to explain the drafting process. She may have emails. She may have warnings. She may have said, we cannot describe it that way. Or maybe she did nothing wrong and just wants protection. Either way, she is now separate. And separation is how unified defenses collapse. First, the document separates, then the stories separate, then the lawyers separate, then the witnesses separate, then the client stands alone. That is the pattern. Now let us put the whole day in order. 9:06 a.m., Judge Marris catches the contradiction. 9:18 a.m., sworn explanation ordered. 9:44 a.m., Atlanta court notified. 10:02 a.m., Atlanta judge demands explanation. 10:42 a.m., distribution chart ordered. 12:18 p.m., Pennsylvania third description surfaces. 1:13 p.m., attorney connected to filing disappears from case duties. 2:33 p.m., Atlanta judge demands control numbers. 3:05 p.m., Trump spokesperson calls it a legal memo, undercutting Washington argument. 3:58 p.m., Atlanta filing claims different versions. 4:21 p.m., native files ordered. 5 p.m., sworn reconciliation filed. 5:46 p.m., limited discovery granted, sanctions reserved. 6:30 p.m., new status conference set. 7:04 p.m., independent counsel rumor hits. One day, 3 courts, 3 labels, 1 memo, and now native files are due tomorrow. That is where the next episode lives, because native files do not care what lawyers say. They show what happened. If the privilege label was added before the subpoena, Trump's team has room. If it was added after the subpoena, prosecutors have fire. If the title changed after the demand, witness 6 becomes central. If the same attorney renamed the file and signed both filings, sanctions become real. If Trump received the memo before it was relabeled, intent comes back into focus. And if the metadata shows someone deleted comments before production, this story jumps from contradiction to cover-up. That is the cliffhanger, not what did the memo say. Who changed what after the government came asking? That is the question Judge Marris just forced into the open. Complete current state. Trump's lawyers are accused of giving inconsistent descriptions of the same election memo in Washington, Atlanta, and Pennsylvania. Judge Marris has ordered sworn reconciliation and limited discovery. Judge Cole has demanded native files and document control numbers. Witness 6 says the label changed after an external demand. A Trump attorney connected to the filing may now have separate counsel. Prosecutors have permission to explore how the memo was labeled, distributed, and described. Sanctions are not imposed yet, but they are on the table. Native files are due tomorrow at noon. Locked variables. Same memo appeared in multiple courts. Different descriptions were used. Same senior attorney signed at least 2 filings. Judge Marris found the inconsistency serious enough to notify another court. Limited discovery is now open. Open variables. Was the relabeling innocent or strategic? Did Trump personally review the memo? Who added the privilege markings? When did legal significance become apparent? What will native files show? Will the associate with independent counsel cooperate? Will sanctions hit lawyers, client, or both? 5 things to watch. 1. Native file metadata. Creation date, modification date, author comments, title changes. That is the heart of the next fight. 2. Witness 6. If the judge credits her account, Trump's team loses the innocent labeling and argument. 3. Attorney separation. 1 lawyer hiring independent counsel can turn into 3. 4. Trump's public statements. Every post gives prosecutors more material to compare against court filings. 5. Sanctions. If Judge Marris moves from reserved sanctions to formal show cause order, the legal team becomes the story. And that is why today is bigger than it looks. This is not a paperwork dispute. This is not a filing mix-up. This is not legal technicality. This is the moment 2 courts realize they may have been told 2 different versions of the same story. And once courts start comparing notes, the old strategy dies. You cannot outrun one judge by telling another judge something different. Not anymore. Not after today. Tomorrow at noon, the native files arrive. And when they do, the question will no longer be, what did Trump's lawyers say? The question will be, who changed the document after the heat arrived? Because in politics, you can rename a scandal. In court, the metadata remembers. Subscribe. Tomorrow's filing decides whether this stays a contradiction or becomes a cover-up.